Welcome to the third episode of Beyond Retirement Learning Series. This is sponsored by Senior Edge Legal, and I'm Susan Graham, a certified elder law attorney based in Boise, Idaho. Today's program will take approximately 20 minutes, and the topic today is estate planning using a revocable trust. My goal is threefold: to give you useful information to help you have a secure future, and to provide free legal forms that everybody needs. In addition, I will show you how you can meet with me if you choose to do that and evaluate me. Just complete the evaluation form at the end of this program or anytime during the program. I know your goal is to gather information and also see if I might be a good team member for you. Now, in earlier episodes, we covered the three pillars of estate planning. The first pillar was evaluate your circumstances and come up with some goals. What you want to do in the rest of your life, in the good days, should you decline and need help, and when you're gone. The second pillar was come up with a plan to get you from here to there. And then the third pillar was actually put that plan in place and keep it up to date. Today, we're going to expand on the second pillar, and that's using an estate plan that has a revocable living trust as part of it. So we're going to talk about what is a revocable trust, how does it work, what are the pros and cons of that trust. When you have an estate plan using a revocable trust, it's like you're setting up a little new business. It's like you're setting up basically a shoebox or a lemonade stand. What it says in the trust is it says that you're in charge, you to decide what the terms of that trust are going to be. That person is called a trust creator, a grantor, a settlor, a trustor. We don't really care what they're called, but that's you, the one who sets it up. And there's another hat that you wear when you set up a revocable trust, and that's the hat of the trustee. That's the money manager. That's the one who's supposed to figure out how to deal with your assets and how to pay the bills and ultimately distribute them out the way you want. There's a third hat that you're going to wear, and that's the beneficiary. That's the person who gets the use of the money during your lifetime, when you're ill, and then when you're gone. When you set up a revocable trust, if you're a single person, you say, I'm in charge of my money, I want to spend it for me. If I get too sick to do it, then someone else is going to handle it. And then when you're gone, someone else is going to handle it and distribute it the way you want. For married couples, it's very similar, except it normally says it's the two of you who are the ones who are the trustees and the ones who created, the grantors or the trust creators. In addition, normally it says one of you gets too sick to handle it, the other one does it. And then it also says when one of you dies, the other one gets it all. Now, there are certainly variations of that, but that's pretty common for long-term marriages. And then if the survivor gets sick, it says who takes over. And then when the survivor dies, who takes over and who distributes the assets out. Now, what's different about a revocable trust versus having a will-based estate plan? Remember, we talked before in an earlier episode about having wills. And what it says in a will, you get to decide who takes over when you die and how your assets are going to be distributed. So a will is only related to death. And a revocable trust covers the good days and when you can't handle things, when you need help with your finances and managing your issues, and then when you're gone. In addition, remember, if you have a will and you die, we have to probate your estate. If you own real property or the total value of all the other assets you own exceed $100,000, it's usually necessary to go through a death probate, meaning someone has to file a petition with the court and file the original will and say, please appoint me as the personal representative, the one to handle the affairs. And then there's court oversight about how things are managed. Now, how is all this different with a trust? First of all, when you have a revocable trust, if you're going to get the maximum value out of it, so this is a trust instrument. Okay, I know this isn't an instrument, it isn't paper, but this is the visual part of it. This is a treasure chest, and it's empty. But what this says in all the paperwork I'm going to pick on a single person, that you are the one who creates the trust. You're the one to decide how the money's going to be managed, that you're going to stay in charge. Normally, you're your own trustee in the beginning, who your backups are, and how it gets distributed when you're gone. Now, to get the maximum value out of a trust, we need to take your titled assets and put them in the trust now, or have them drop in automatically when you die. Remember, when we went, you only had a will, or even no will. When someone dies, it all comes down to who's the money manager, who can sign on behalf of that dead person. In a will, it says who's the personal representative. If you don't have a will, the Idaho legislature has figured out who's going to be the one in charge. So when you have a revocable trust, it says you're in charge, and you decide who's going to be the successor trustee behind you, the backup. So to make it work, in the beginning, you're going to take the deed to your house and take it out of your name and put it in your name, trustee of your trust. So for me, I put my house title in the name of Susan Graham, trustee of the Susan Graham Trust, and I put it in the trust. I was fortunate, and I inherited a farm from my grandparents. So it's in a different county. So I did another deed, taking it out of my name, putting it in my name, Susan Graham, trustee of the Susan Graham Trust, and recorded that deed in that other county. If I owned property in the neighboring state, in Oregon, I would have an Oregon attorney do the same thing and put my Oregon property into the name of the trust. I put my brokerage account in my name, Susan Graham, trustee of the Susan Graham Trust. Now, on my brokerage account, they need a tax identification number. That would be my own Social Security number. You don't need a separate tax ID number for this trust. I'd make my bank account a paid-on-death account, so the checks stay the same. But when I'm gone, somebody who's my successor trustee can go down to that bank, file a certified copy of my death certificate, and they will write a check out to them. So-and-so, the trustee of the Susan Graham Trust. I'd make the beneficiary of my IRA the trust. I'd make the beneficiary of my life insurance the trust. Okay, so now all the assets are titled in the name of the trust. So now what's different in terms of estate planning? Well, if I become incapacitated, mentally or physically can't handle my affairs, we don't need to worry about a conservatorship and a guardianship, because I have language in the trust that says if I resign, of course the other person can take over. So if I'm too ill to manage it, but I'm still competent, still mentally or physically know what's going on and can sign the documents, I can resign, and my successor trustee can sign a paper that says they'll take the job. We file that at the courthouse, and they're instantly in charge. In addition, if I'm so incompetent, I've had a stroke or I've had a car wreck and I can't really even have the capacity to resign, if they get a doctor's statement, because that's the language that's in this trust, the person who created it, me, can decide on that language. So if I say, if a doctor says I'm incompetent and my successor trustee says they agree and they're willing to take the job, they file that with the court, they're instantly in charge. So there's not the delay, if someone becomes incompetent with a trust, of having to go through a court proceeding for conservatorship and guardianship proceeding. And we talked about that before. That's a pretty crummy proceeding to have to go through, because the petitioner, let's say I name my oldest child, be the one to handle things. That individual has to have an attorney. The court requires another attorney be hired to represent me. Often a third attorney is the one who's called the court visitor, who goes out and talks to everybody and makes a recommendation to the court. And then we have a doctor who does an evaluation of me. You take those four professionals, it's not hard to run up the bills pretty fast. And often it's $5,000 to $10,000 to go through those proceedings. In addition, it takes time to get all that work done. So it's not infrequent that it's 3 months or more before a conservative guardian will be appointed to be able to handle my finances and make my health decisions. So nobody in their right mind wants to do that one. And that's why it's much easier with a trust that's actually, we call it funded, meaning we transferred the titles into the name of the trust, or we had them automatically drop in when I die. Now let's talk about the day I drop over dead. The day I'm dead, what will happen is the successor trustee will get a certified copy of my death certificate and record that in the county where the original trust was recorded, and they will sign a statement that says they'll take the job. They also need to get a new tax identification number. My social security number no longer counts because I'm dead, so they need a new tax ID number. But once they file that information, then they can take over. They can sign the deed to sell the property. They can sign the deed in Oregon to sell that property. And they can go to the brokerage firm and gather up my assets. Now, they'll want to open up a new bank account to put on the name of the trust with this new tax ID number to put these assets into that they gather up. They also have to give notice to the heirs, showing them what they're doing with the funds. But after they get through this whole process, then they also will notify the heirs and say, okay, this is what came in, this is what went out, this is what we started with, this is what's left over, and this is the distribution. And send them a proposal. That's what we usually do in our office. We send that accounting information and a proposed distribution to the heirs, and if everybody signs off, then the check is written to them or the asset is distributed to them. Normally, when you do a death administration using a trust, whoever the trustee is will also hold back some of the money in case there's some new bills that come out that you never anticipated. And usually that money that's held back, I'm making this up, but let's say $10,000, that's there, and the trustee then pays whatever miscellaneous bills that are appropriate come through after the money's distributed. And then usually after another year goes by and they figured out there's nothing more coming, then they show what's been going on in that bank account and write a check to the people who are supposed to receive the remainder. You don't want to, if a new bill comes in and you distributed all the assets because you were the trustee and you thought you were all done, and then, oops, another bill comes in that you never anticipated that's a legitimate bill, you don't want to call these people up and say, send me back $752. Some of them won't have it, some of them will refuse, so it just makes a lot more sense to hold back some money and then distribute the balance out later on. Another nice feature of this is if you have property in a neighboring state, such as the state of Oregon, when the trust owner dies, it will not be necessary to probate that estate in the state of Oregon. What happens when someone dies and they have real property in their name and they own property in another state other than the state where they were residing, it's necessary to probate that asset. Remember, probate is get the dead person's name off the titled asset, get it where it's supposed to go. Well, if the titled asset of that Oregon property was in the name of the trust, it's not necessary to probate that estate in Oregon. Again, the successor trustee would get a certified copy of the death certificate and sign the deed, and that would be sold or transferred to one of the heirs of this trust. So that's the way a revocable trust works. And to make it function, it's really important to put all the titled assets in the name of the trust or have them transferred automatically at death, again, as a beneficiary designation or a paid on death designation or a transfer on death designation. So, what are the cons about this, having a trust? Well, first of all, you got to do that homework. And a lot of people never get around to doing that. They never do put the deeds in the proper name or change the brokerage account or make the IRA or the 401k, ultimately the trust as the beneficiary, or make their bank accounts in the name of the trust. Or they do that in the beginning and then time just goes by. They sell their house, they downside, they buy a new house, and they put the new house in their individual name, not in the name of the trust. And then they die. Well, when that happens, then again, we have a dead person's name on real property, and it's necessary to probate their estate. So when you do a trust, there are other papers that you need to sign. One of them is the last will and testament. Now, it says last will and testament, and it's a different version than if you only had a will-based estate plan. That will says, if you goofed and left something titled out of the name of the trust that needs to be probated, it says appoint someone, usually that's the same person who's your trustee, as the personal representative, and then they have the power to sign the deed to transfer the property into the trust, and then things get administered under the terms of the trust. That kind of will is called a pour over will. Pour, like a pitcher, pours money into the trust. So that's one of the disadvantages of a trust. You've got to pay attention. You can't just let your life drift away and not keep your assets coordinated with a trust, titled in the trust, or set to automatically drop in the trust when you're gone. Another disadvantage is obviously this takes some time. So there's a lot more busy work at the beginning when you set up a trust. And because of that, and because of the other documents that are necessary, like in our office, we help our clients make sure that they align their assets properly. And because of that and the extra time it takes, it costs more to set up a trust-based estate plan in the beginning. So you can anticipate that the fees that are going to be charged for a trust are substantially more than just a last will and testament. There are many other documents that go with a trust-based estate plan. There's a will, there's also all the deeds, there's the funding documents, there's financial powers of attorney, there's health documents. We also register the trust in the county. That's the only official court document that says that you have a trust and who your backups are. Nothing about what you own or who gets it when you're gone. So a revocable trust is another version of planning, a planning technique that gets you from where you are to where you want to be for the rest of your life, in the good days, the bad days, and then what happens with your property and the people you care about after you're gone. I want to encourage you to fill out that evaluation form and click the button so that if you do that, then we'll have those forms available for you at no cost. Again, if you want to visit with me, there's no charge for that first meeting, but there will be some questions that'll be asked to see if we have the potential for being a good fit. I want to thank you for listening to this program. The next topic is going to be irrevocable trusts. Thank you.